video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments and justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
Hey, Jamie Carper here. Today's case answers a question that sounds technical, but goes straight to the soul of constitutional law. Can the government hold people indefinitely outside the United States and place them beyond the reach of the courts? The case is Boumediene v. Bush, 553 U.S. 723-2008. Here's the background, clean and precise. After September 11th, the United States detained hundreds of foreign nationals at Guantanamo Bay, Cuba. The government labeled many of them enemy combatants and held them without traditional criminal charges. Congress and the executive created a review system, the Combatant Status Review Tribunals, or CSRTs, to determine whether detainees were properly classified. Congress then passed the Military Commissions Act of 2006, which attempted to strip federal courts of jurisdiction to hear habeas corpus petitions from Guantanamo detainees. Several detainees, including Lakhdar Boumediene, challenged that scheme. Lower courts? The D.C. Circuit held that Guantanamo detainees had no constitutional right to habeas corpus, reasoning that Guantanamo was not sovereign U.S. territory and that Congress had provided an adequate substitute through the CSRT process. So the Supreme Court steps in. Here are the questions before the court. Does the Constitution's suspension clause apply to non-citizens detained at Guantanamo Bay? If it does, did Congress validly suspend habeas corpus? And are the CSRT procedures an adequate substitute for habeas review? In short, does the Constitution stop at the water's edge, or does it follow the power of the United States?
We'll hear argument this morning in Boumediene versus Bush.
Mr. Chief Justice, and may it please the court. The Constitution does not extend habeas corpus rights to alien enemy combatants detained outside the sovereign territory of the United States.
But the United States exercises complete control over Guantanamo, does it not?
Control, yes. Sovereignty, no. And sovereignty has always mattered.
If the government can choose a location where courts have no reach, doesn't that raise serious constitutional concerns?
Congress provided an adequate substitute, the CSRT process and limited appellate review.
Adequate compared to what? Habeas has historically been robust.
National security requires flexibility, Justice Kennedy. Habeas is not feasible in wartime detention.
And extending habeas here risks judicial intrusion into military affairs.
Mr. Chief Justice, and may it please the court. The suspension clause protects the writ of habeas corpus wherever the United States exercises complete and permanent control, especially when individuals are detained indefinitely without trial.
So your argument is that sovereignty is not the sole test?
Correct. The Constitution limits government power, not geography.
In the CSRTs?
They are not an adequate substitute. Detainees lack meaningful access to evidence, cannot compel witnesses, and face presumptions favoring the government.
So, without habeas, there is no meaningful judicial check.
The suspension clause protects a fundamental precept of liberty. The question is functional where the United States exercises complete control. Constitutional limits apply.
This is unprecedented. We've never extended habeas this far in wartime.
We've never faced a detention regime like this, indefinite, offshore, and deliberately insulated from courts.
If Congress wishes to suspend habeas, the Constitution requires rebellion or invasion and a clear suspension.
And even then, a substitute must be adequate.
The CSRT process is not. It lacks the core protections of habeas, meaningful fact-finding, and judicial independence.
If the political branches can switch off habeas by choosing geography, the suspension clause becomes optional.
The court is risking national security. The court is enforcing constitutional structure. Liberty and security are not mutually exclusive.
Justice Kennedy has the opinion of the court.
The question before the court is whether foreign nationals detained at Guantanamo Bay have the constitutional privilege of habeas corpus, and if so, whether Congress validly suspended that privilege. The suspension clause of the Constitution provides that the writ of habeas corpus shall not be suspended except in cases of rebellion or invasion when public safety may require it. That clause is a fundamental safeguard of liberty. ensuring that the executive may not detain individuals indefinitely without judicial review. Although Guantanamo Bay is not formally sovereign United States territory, the United States exercises complete and permanent control over the base. The Constitution's reach, therefore, does not turn on formal sovereignty alone. Instead, we apply a functional approach, examining practical considerations and the nature of the government's authority. Under that approach, the detainees at Guantanamo are entitled to invoke the suspension clause. Congress did not formally suspend the writ. Instead, through the Detainee Treatment Act and the Military Commissions Act, it attempted to strip federal courts of jurisdiction and replace habeas review with the combatant status review tribunals and limited appellate review. Those procedures are not an adequate substitute for habeas corpus. The CSRT process places a presumption in favor of the government's evidence, restricts the detainee's ability to present evidence, and limits meaningful judicial review of factual and legal errors. Habeas corpus, by contrast, has historically required an independent judge with authority to assess the legality of detention. The separation of powers demands that the judiciary retain a meaningful role in reviewing executive detention. The political branches may not, by statute, switch the Constitution on or off at will. Accordingly, we hold that the detainees are entitled to seek habeas corpus relief in federal court and that the jurisdiction-stripping provisions of the Military Commissions Act are unconstitutional as applied.
I join the court's opinion and write separately to emphasize a central point. The Constitution's guarantees are not confined to formal borders. Where the United States exercises plenary and exclusive control, constitutional limitations apply. To hold otherwise would permit the political branches to evade judicial review simply by selecting the place of detention. The court's decision today reaffirms that the suspension clause is a structural protection, not merely an individual right, and that it functions as an essential check on executive power, particularly in times of conflict.
I respectfully dissent. The court today strikes down a system that Congress enacted to provide a substitute for habeas corpus during an ongoing armed conflict. In my view, the procedures established by Congress, including the CSRT process and review by the D.C. Circuit, are a constitutionally adequate substitute. The majority undervalues the degree of judicial review already provided and disregards the political branch's careful efforts to balance liberty and security. This decision will create uncertainty and invite litigation that interferes with military operations. The Constitution does not require the court to second-guess Congress's considered judgment in matters of war and detention.
I join the dissent. The court's decision is unprecedented and dangerous. Never before has this court held that alien enemy combatants detained abroad possess constitutional habeas rights. The practical consequences are severe. The court has imposed judicial oversight on military detention in the midst of an ongoing war. The majority's functional test replaces clear rules with judicial discretion, leaving the political branches uncertain of their authority and responsibilities. The Constitution assigns the conduct of war to the elected branches, not to judges. This decision will almost certainly cost American lives by hampering the nation's ability to detain and interrogate enemy combatants.
Here's the holding, no shortcuts. The Constitution's suspension clause applies at Guantanamo Bay. Congress cannot strip detainees of habeas corpus without a valid suspension, and the CSRT process is not an adequate substitute. Why does this case matter? Because it says constitutional limits follow U.S. power, not formal sovereignty. Because it reaffirms that habeas corpus is the great safeguard against indefinite detention, and because it draws a firm line, the political branches cannot create a law-free zone by clever geography. This case didn't decide who should be released. It decided who gets a judge. And in constitutional law, that difference is everything. I'm Jamie Carper, and remember, liberty survives when courts remain open, especially when fear is strongest.